Hello, everyone, and welcome to today's webinar on Deferred Action for Childhood Arrivals, otherwise known as DACA. My name is Sally Kinoshita, and I'm the Deputy Director of the Immigrant Legal Resource Center, also known as the ILRC. And I'm so pleased to be joined today by my colleagues here at the ILRC, Sandy Valenciano, Allison Davenport, Veronica Garcia, and Krishna Avila, who you'll hear from later today. We'll get started in just a minute, but before we do, I just wanted to cover a little bit of logistical and background information. If you have any technical issues during the webinar, please contact GoToWebcast, which is the webinar platform, at 1-888-860-6814. Or if you're having problems with getting the materials for today's webinar, registration questions, and other issues related to that, please contact Helen Leung here at the ILRC. Her email is hleung@ilrc.org. Also, just to let you know, after today's webinar, you will receive an email from the ILRC with a survey for your feedback. So please respond to us and let us know what you thought. During today's webinar, we will be taking questions through the chat box, which you can see on your screen under Ask a Question. Given the large number of attendees at today's webinar, we do not anticipate being able to get to all questions. However, we'll try to get to as many as possible through the chat box. We'll also stay on for a few minutes after to try to continue to answer questions through the chat box. So we'll stay on for an extra 10 minutes or so to try to get to as many as we can. Also, to let folks know, we can't answer any case-specific questions, but I'll let you know in a moment how you can get more help on case-specific questions. For those of you who are not familiar with the Immigrant Legal Resource Center, the mission of the ILRC is to work with and educate immigrants, community organizations, and the legal sector to continue to build a democratic society that values diversity and the rights of all people. We train attorneys, paralegals, and community-based advocates who work with immigrants around the country. We inform media, elected officials, and the public to shape effective and just immigration policy and law. And we work with grassroots immigrant organizations to promote civic engagement and social change. We do not provide direct legal services. However, we do have an Attorney of the Day service as part of our technical assistance that is available Monday through Thursday, 10 a.m. to 5 p.m. And we have a staff of attorneys who can answer case-specific questions and other inquiries about immigration law and practice. This is not a hotline, it's more like a warm line where you can leave a message and one of our attorneys will get back to you. The contact information for this is there on your website, on your slides at aodadmin@ilrc.org to set up a contract, or go to our website for more information. This service is actually free to many of you who are listening today. For example, it's free to all California Department of Social Services contractors and subcontractors, all IOLTA-funded organizations in California, all Bay Area nonprofits in the San Francisco Bay Area, and all of our New Americans campaign partners who have naturalization questions. All others can also access this service on a prorated fee. All right, so about today's webinar. After a long battle, the recent U.S. Supreme Court decision has restored the DACA program, allowing for both renewal and first-time DACA applications, but there's a lot of continuing uncertainty about the future of the program. On today's agenda, you will see on this slide, we will go through a bit of the background and context of DACA and then talk specifically about what the Supreme Court of the United States, also known as SCOTUS, decision says and what the impact will be. Then we'll talk a little bit about both initial and renewal DACA applications, some red flags to look out for, decision-making around applying, and some potential scenarios. And finally, we'll talk about how you and your clients and community members can continue to be involved in the movement and advocacy. For now, I'll turn it over to my colleague, Sandy Valenciano, to talk about some background and the current context of DACA. Sandy, go ahead.
Hi, thank you so much, Sally, and for providing that important context. And I just wanted to use this opportunity to build more on our understanding of how this great victory was achieved and also how this allowed us to really be innovative in the way that we think about our organizing and our policy victories. And so as most folks know, DACA was a community-led victory where undocumented youth risked putting their bodies on the line to, more importantly, hold Democrats accountable for promises in terms of permanent protection from deportation, as well as divesting from immigration enforcement. The undocumented youth movement has largely shifted the immigrant justice, immigrant rights movement. In particularly, a lot of us recognize this undocumented, unafraid movement that came out of an effort called Coming Out of the Shadows, which is really the empowering folks and builds out the power of storytelling. And what that means is that undocumented youth really empowered each other to come out with their stories and build community amongst each other in terms of what folks were experiencing, and particularly around immigration enforcement. And for some of you all who joined our prior webinar, you all might have seen some of the pictures I shared from the direct actions that young people held inside of electoral offices. And more importantly, DACA was achieved because undocumented youth challenged Obama's reelection and his platform, right, and promises that were being made for permanent protections. And so, I want to give a big acknowledgement for that. There has now been 2 decades of undocumented youth organizing and leadership, and that is very different than, where we were at originally with DACA implementation and some of those efforts early on. And so to share with folks additional background and context of DACA, part of those two decades of undocumented youth movement have really taught a lot of us a lot about organizing with undocumented youth, and just a lot of opportunities that come when we're implementing these policies for permanent protections for undocumented youth, as well as how do we maximize these interactions that we're having with impacted communities, and how are we actually building stronger communities in the interactions that we're having with people who are the most impacted by immigration enforcement. And so some of the things that I have learned, I was very fortunate to be a DACA recipient and be a DACA recipient early on when DACA was first implemented, but I also had such a great opportunity to actually help enroll, I think it was that first fall, over 700 young people into DACA when I lived in the North Bay part of California. And I learned that there was just so many untapped opportunities when we have folks waiting in the lobby, right? When we have folks, maybe waiting outside with their families as they have their documents reviewed, is how are we, using these interactions to provide political education opportunities, to provide more information in terms of, do folks know what enforcement looks like in the area, right? And to also think about, if we anticipate a wave of young people coming to us and seeking more information about protections from immigration enforcement, how are we also giving them information that they can disseminate within their families, right? Just also wanted to share with folks that there's a huge range of who undocumented youth is, and also who DACA recipients are. Like I shared, there has been now 2 decades of undocumented youth.
Your entry is not valid.
Can folks hear me? Hello?
I can hear you, Sandy. Sandy, I can hear you. Go ahead.
Okay, I'm sorry. And so like I was sharing, right, so there's a huge range of who undocumented youth are. There were folks that initially applied who are now in their mid, late 30s. There are undocumented youth who, did not meet the age eligibility to be able to apply initially. And there are also undocumented youth that, were fearful of applying and will continue being fearful of applying. There's undocumented youth that met all eligibility but were criminalized, right, based on that the convictions eligibility. And so really thinking about how are we providing and how are we creating spaces where we're actually meeting the needs of multiple audiences of undocumented youth, really understanding its complexities. And there's some really great data that also begins to delineate who will be eligible for DACA. And some of the numbers, just to share with folks, right, young people from China, only 600 folks benefited, but there are 23,000 eligible young people. Young people from India, there is only 2,000 folks that were eligible that benefited initially, but there's 17,000 people that are eligible, and could be recipients. And so, for us, really pushing narratives of who undocumented youth are, and really challenging ourselves and how are we providing broad services for undocumented youth when, we're going to anticipate to have undocumented youth seeking services who will not be eligible for DACA. Just to build off what I was sharing before about coming out of the shadows, this is really, coming out of the shadows is so important and so symbolic because, again, we're telling stories of, that there is not a one identity of who undocumented youth are. And I just want to acknowledge that the undocumented youth, unafraid, coming out of the shadows movement really came from undocumented queer, trans, and gender non-conforming folks. For some of you all who are watching this from your screen, you will see that for some of the folks that are seeing this on the screen, you will see a picture here of my comrade, and some of the undocumented youth that are unaccounted for are also undocumented youth that have chosen to self-deport. And so my comrade, Cesar Magallon, who is on the screen here, is also part of those unrepresented undocumented youth who have chosen to leave as well. Another big thing I think that we need to be mindful and aware of in terms of context and opportunities with DACA is that undocumented youth continue to and have been bargaining chips for enforcement. And we saw this under the Obama administration where even though DACA has been a great program that has supported many young people from deportations, it also brought upon the priority enforcement program. And the reason why the priority enforcement program was strategically announced with DACA is that it started creating these narratives and perpetuating narratives of who is the deserving immigrant and who is not. And so we heard narratives from the administration such as, felons, not families, and not really considering that felons are also part of families as well, right? And so always thinking about that as well in terms of the history of DACA and how we can be better at implementing DACA and not give into criminalizing narratives that have been created around this program. And like I mentioned, we've seen it, in the news recently where the administration announced that it was going to give a pathway to citizenship for DACA recipients. And, we constantly hear undocumented youth being part of negotiations and bargaining between parties and administrations. And so, and we also saw that with even the recent visa, right, rescinding announcement, and how the administration strategically used this to, push for for the universities to open. And so, thinking about how undocumented youth will continue to be used as a bargaining chip is really important in terms of context, and also in terms of the ways that it's our responsibility also to make sure that we break the criminalizing narratives that administrations continue to use when they use this narrative of, you know, who is the deserving immigrant and who is not a deserving immigrant. And, you know, also a reminder that even though some young people are eligible for DACA, have been eligible, and have received DACA, there are undocumented youth who continue to be targeted by immigration enforcement. And so, for example, the story of Beto, who was a young person who was in Chicago, who had his DACA renewal denied and was deported recently. There's the story of Claudia Rueda, who is someone who is a DACA eligible youth, but has been explicitly targeted by border enforcement, by ICE enforcement. Her whole family has been targeted by immigration enforcement, and she currently has a case against the Department of Homeland Security for discriminating against her and not approving her DACA for no apparent reason. There's a story of Valeria, you know, undocumented youth who isn't eligible for DACA, who was criminalized and targeted when she took a domestic flight. And so, you know, just for us to understand that the identity of who undocumented youth are is a large range, and there is not one identity to who undocumented young people are. And also for us to acknowledge that there are undocumented youth that are still being targeted by the police, by CBP, by HSI, by ICE. And so we must always push more and uplift the narratives of the young people and undocumented youth who continue to be left out of permanent protections, and always ask ourselves, you know, why are groupings of folks being left out, and how are we challenging criminalizing narratives that narrow permanent protections for our communities. Thank you.
Great. Thanks so much, Sandy. I think it was so important to provide that context. We're going to take a deep dive into the DACA program right now, but it's so important to remember kind of the context of how that program started 8 years ago and all of the efforts by undocumented youth to make that a reality, and also to place DACA in this larger context of our current policy and enforcement regime. So we're going to kind of switch gears and kind of think about now what this SCOTUS decision means for the DACA program, DACA recipients, and DACA eligible individuals. So I know we have all read about the recent Supreme Court decision, but we're going to take just a few minutes to review and clarify what that decision says and what it means, so that we have, you know, a shared understanding of that as background for the rest of the webinar. Let's take a minute to just quickly review the timeline. So we all know that DACA was a big campaign issue in 2016, and we saw candidate Trump and then President Trump flip-flop on the issue several times. Finally, after threats from anti-immigrant forces, the termination memo, also known as the Duke memo, was issued in fall 2017, and there was a brief wind-down window for the program. Several lawsuits were filed in response to that termination. There have been separate legal challenges to the DACA program itself, but what we're focusing on today is the challenges to the termination of the program. Those lawsuits resulted in federal injunctions or court orders that required USCIS to continue with DACA renewals. So it did allow initial applications and advanced parole applications to be suspended, but it did require that DACA renewals continue. In 2019, 3 of those cases, had wound their way through the legal system and were consolidated before the Supreme Court, which heard oral arguments in that case in November 2019. We have been waiting since the beginning of this year for that decision to come out, and there was some attempts to request the court to delay a decision given the pandemic that we're experiencing in the country. But the SCOTUS decision was issued on June 18th, and in a 5-4 opinion, the justices held that the termination of DACA was not valid under federal law. So let's unpack the decision just a little bit. And I think the main takeaway is that I think the headline in the news was that the court upheld DACA as if it somehow made DACA, enshrined or guaranteed. But what the court really did was reject the termination of DACA. It did not rule on the legality of the program itself. And basically, because DACA was created by executive actions, it's not federal law, it was not passed by Congress. One administration like the Obama administration can create such a program, and in another administration like the Trump administration can change it or terminate it. So it's not whether they can terminate it. All parties, including the DACA recipients in the case, agree that the administration can terminate it, but how they do it and why they do it matters. So the court said that, first and foremost, that they did have the right to review the decision to terminate. It had authority over this executive decision because it was not purely discretionary, so it was subject to legal review. And then the court kind of dove into the legal analysis. And basically they said it did not meet the standards set forth under the Administrative Procedures Act, which is kind of the federal law that guides the actions of our federal agencies. The court found that the Duke termination memo offered a legal conclusion. It simply stated that the program is illegal rather than providing a detailed analysis. There was some subsequent reasoning offered by the administration for the termination. Former DHS Secretary Nielsen had made some statements, things like that, but the court said the termination has to be reviewed based on the reasons the agency gave at the time. So there was insufficient justification provided. It also found that certain aspects of the program were not properly considered by the agency. So there was a big focus on the benefits of DACA, such as getting a work permit, but it didn't consider the main feature of the DACA program, which is protection from deportation. Deferred action is, in essence, protection from deportation. So terminating based on benefits alone was not sufficient because it failed to address the central feature of the program. The court also found that the agency failed to consider how DACA recipients and different institutions they're connected to, such as their employers or educational institutions, had come to rely on the program. So there was no analysis of what the impact of termination would be. The DACA recipients had also raised another argument challenging termination, saying that it was in part motivated by an intent to discriminate against Latino immigrants due to statements made by the president, and that is a violation of the Constitution. But the court rejected this argument, saying that because the majority of undocumented immigrants in the United States are Latino, such an argument could be made about any immigration policy or program, and that the termination itself was done by Duke and Attorney General Sessions, not President Trump, and so his statements about Latino immigrants and specifically Mexican immigrants were not necessarily illuminating, in the words of Chief Justice Roberts. So that's kind of where we are with the DACA decision. What does all of this mean? So obviously it means that the administration, we know this already, that the administration can terminate the program, but how they do it matters. It also means that another termination is possible, and we have heard indications that such termination 2.0 could be imminent. The decision in kind of describing why the decision to terminate or the termination memo did not meet the standards set in federal law, it also provides an outline for the administration to issue a second termination memo, which does meet those standards laid out in the Administrative Procedures Act. So, like all legal decisions, when it says, how you met the legal standard or didn't meet the legal standard, it essentially provides a roadmap for doing so in the future. We do believe that the decision restores the program fully, exactly how it was before the termination memo. So basically the reasoning is if the termination was illegal, then we go back to what existed before. And the full DACA program includes not only renewals, as it did under the injunctions that were put in place, but also includes initial applications and advanced parole. I know there's a lot of questions and a lot of interest in initial applications and advanced parole, and we're going to use the bulk of our time together today to think through those issues. Another kind of a troubling feature about what all of this means is that normally we would look to the agency in question to implement a decision of the Supreme Court and get some update about how they're planning to move forward in light of this decision. But USCIS has not really provided any guidance or update about how they're planning to implement this decision. Their website, the DACA page on their website, doesn't contain any information. It's basically frozen as of the injunctions that were issued in early 2018. It's highly unusual given that several weeks have already passed. In fact, I believe tomorrow will mark 1 month since the Supreme Court decision. And this is already an existing program. It's not a new program where they have to create forms and processes and criteria. It's an existing program that would just need to be reactivated. So that's also, another factor in how this Supreme Court decision is having an impact. So just very quickly thinking about what does this mean in terms of DACA recipients and DACA eligible individuals. Obviously for renewals, as a practical matter, nothing has changed. People can and should continue to renew their DACA cases. If you've ever had DACA or you have DACA now, you can apply for renewal. It doesn't matter if your case expired recently or many years ago. You are eligible to renew your case. It also means people whose cases have been terminated are eligible to renew once again. We always want to encourage people to get a consultation before they renew, especially if they've had any contact with law enforcement since their last DACA case was approved. And my colleague Veronica is going to talk about that a little bit more in a moment. In terms of initials, and I know this is where a lot of the questions are, we're going to discuss this more fully, but the decision should fully restore the program, including for initial applications. We're going to walk you through some guidance, not only about what the initial application process looks like, but how to make that decision about filing for DACA at a first time. But we do recommend at a minimum that interested individuals begin to collect any necessary evidence and documentation. The program does require presence going back to 2007, so that's, quite a long period of time, and with the pandemic and so many closures, it can be complicated. And we also really encourage people to get an in-depth consultation to assess their eligibility for DACA, but also for other forms of relief. Okay, and then just very quickly, since the SCOTUS decision, there's several moving pieces here that makes this kind of landscape even more complex. So of course, again, USCIS has been radio silent in terms of their communication with the public about how they're going to implement this decision, other than a statement saying they don't agree with the Supreme Court's decision. There's been no guidance on their part. Immigrant advocates and members of Congress have written letters demanding clarification and action on the part of the agency, so we'll have to wait and see if that has any effect. We also have heard rumors that a termination 2.0 is coming. We've heard, a couple weeks ago, we heard that it was coming out in a matter of days. There's really not any concrete information, but I think everyone needs to be prepared for that possibility coming very soon. We also heard last week from President Trump during a media interview that he plans to sign off on some new program that would be a merit-based program and helpful to DACA recipients and would provide a path to citizenship. He referred in the same interview to an executive action and to a bill and a law, so it's very unclear what exactly he's referencing. His spokesperson later clarified that there's some deliberations around executive action, but we don't have any clarification about what that exactly looks like or what the plan is, whether a second termination memo and a new executive action would be issued at the same time. So this is a lot of confusion, And, I think what we want to do is just ground us in all the available information we have at this point so you can make the best decision for yourself or work with your clients to make the best decisions for them. So I know initial applications are a hot topic, so I'm going to pass over to my colleague, Veronica, to walk us through renewals and initials.
Thank you, Allison. So I'm going to go over the requirements for an initial application as well as renewal applications, and also discuss some of the things that have been coming up with those who have filed initials, and then best ways to document each application, because whether you choose to move forward or to wait, we want to make sure that all applications that are submitted are well documented and completed so that no issues come up because of that. So just to start us off, I want to briefly go over what the requirements are for someone to be eligible for DACA. Many of us haven't seen these in many years, right? Since for the past 3.5 years or so, we've only been doing renewals. So individuals to be eligible for DACA had to meet these 7 requirements, right? They had to show that they were born after June 15th, 1981, that they came to the United States before their 16th birthday, that they continuously resided here since June 15, 2007. So those are the 13 years of continuous residence they would have to prove if they submit an initial now. They have to show that they were physically present in the U.S. on June 15, 2012, and at the time of applying, that they were undocumented on the as of June 15, 2012, and that they met the education requirement as well as not having been convicted of certain crimes, which we're going to go in more detail in a bit. Individuals who met these requirements, USCIS granted them 2-year permission to remain in the United States, right? So 2-year protection from deportation. Individuals were also given a work permit so that they could work lawfully here in the United States, and the ability to renew every 2 years. Those who had any cases in immigration court, those were closed if they were granted DACA, and then people were able to get a Social Security number, right, with their work permit as well as a driver's license. Okay, so now for initials, I'm going to go into more detail as to how someone would go about meeting these requirements, because for an initial application, you have to show proof of each of those to show that your client is actually eligible for the program. Before going into what those requirements are, or how you would meet, the evidence you would submit to show that you meet those requirements, I do want to start us off with what the current state of initial applications are. I know there's a lot of discussion around this, right? And there's a lot of unknowns around how they're being processed. And as many of you probably heard or have read, there was at least one rejection since last week of an initial application that was filed, right? So for the current state of things, right, as Allison mentioned, based on the SCOTUS decision, right, what the Supreme Court decided, USCIS should be accepting DACA initials, and there's no need to wait for any guidance, right, to come up on their website for them to accept these applications. DACA applications for initial applicants have been filed by different organizations throughout the United States, and some of them have heard nothing back from USCIS, and some of them haven't gotten the fee, right? The check hasn't been cashed, right? And like I mentioned, we did hear of an initial application being rejected, and we're waiting to see how many more have been rejected. There is some talk around doing a class action lawsuit for the rejections, and different attorneys have, decided as this being a factor as to why they would submit now, which Allison will talk a little bit more towards the end of this presentation. I do want to note that the application was rejected, right? So to our knowledge, the person's fee was returned as well as their whole packet, right? It was rejected in the lockbox. It wasn't denied, right? So it was not processed. And it seems because it was rejected there, the applicant's information wasn't input in the system. But, this is what we know. And hopefully in the coming days, we'll get a little bit more clarity on that. Okay, so anybody who files an initial DACA application will have to prove that they meet the 7 requirements listed on the screen. Right, an individual looking to apply for the first time will need to meet these requirements, right, and show that they meet the age requirement of having been under 31 as of June 15, 2012, have that they came to the United States before their 16th birthday, that they were physically present on the day the announcement was made, which was June 15, 2012. They will have to show that they were undocumented that day, that they meet the education requirements, have not been convicted of certain crimes, and prove that they continuously resided in the U.S. since June 15, 2007. For proving age and identity as part of your application packet, individuals could have submitted passports or birth certificates with an accompanying ID. You basically could submit anything that shows your identity and that shows who you are, right? So a school ID with photo would work. Any other relevant documentation could be shown for this. Right? You would have to prove that you came here before the age of 16, right? So you could show this by, if you came in with a passport, right, and you have an admission stamp, you could use that. If your client came earlier and was enrolled in school records are a great way to show this. Any other government documentation you might have that shows entry, or hospital or medical records, right? Some children who came here really young were vaccinated here in the United States, so you could definitely use that to prove arriving before the age of 16. A quick note on arriving. There are some clients that you will come across, or some individuals who came before the age of 16, but were only here for a brief visit and then exited and, entered again after that, maybe when they were 17 or so. For this requirement, USCIS wants to know that they basically have resided here. I'm going to speak a little bit about travel in a bit and how that could affect, but basically showing that, the person came and actually set up residence here in the United States is good, right? You could do that with work evidence or school or leases if they have them, right? And you want to check this for people who might have traveled back and forth. Maybe some people had a tourist visa and were able to enter and exit. So just make sure that you prove that they were in fact living here and were not just visiting here. The next set of requirements of continuous residence, physical presence, and immigration status, right? Here the applicant's being asked to prove that they were here for key dates, right? So the first one is continuously resided in the United States since June 15, 2007 up to the present. Right, so here, an individual who's applying today will have to submit evidence of the 13 years, right? Best practice is to have at least one piece of document for every month. If you don't, it's okay to have a gap of about 3 months. Those were being approved and okay when initials were being allowed back, prior to the termination memo. So we're hoping that will be the same for now as they begin to hopefully to be adjudicated once more. The person will have to show that they were physically present in the United States on June 15, 2012, right? Here USCIS has asked at times to have documentation of someone being here that day, so something that shows the date. I know that's not always possible, right? Because who has a receipt notice or save something that shows June 15, 2012 in particular? If you don't have that, you could also use something around that date to show that they were in fact here when the announcement was made. Lastly, right, you will have to show that they were here unlawfully present on the day the announcement was made, which is June 15, 2012. It's okay if the applicant entered on a tourist visa or had other lawful status, but it has to have expired on that date for them to be eligible for the program, or expired before this date for them to be eligible for the program. A quick note on travel, right? So, travel outside of the United States would break continuous residence during the period between June 15th, 2007 up to August 15th, 2012. Right. There are some individuals who might have traveled for a short trip, either to go to a family funeral or to deal with a family issue. Not all travel breaks continuous residence. If the individual could show that it was brief, casual, and innocent, meaning that it was short, that it was for a specific purpose, right, and they just came back after that event was done. I want to note that if someone's exited the country because of a removal order or because of a voluntary departure. It doesn't matter if they were only out of the country for a few hours before they re-entered. If that happened after June 15, 2007, that would break continuous residence for this. Also, I want to note that if anybody traveled after August 15th, 2012 without advance parole, then that breaks, right? And they are no longer eligible for the program. So definitely be sure to look out for this. Also, if you're doing any renewals, to look out for anybody who might have traveled after this date without advance parole. Proving continuous residence will require, and physical presence will require you to gather a lot of documents. For younger applicants, it's a lot easier to prove this because you could just get school records, either letters or transcripts or attendance records, class schedules. For older applicants, it's a little harder. They would have to, some people got really creative on how to show, that someone was here. People have relied on medical records, rent receipts or utility bills, letters from companies showing that they were here during the date. If anybody was enrolled in the Army, you could definitely use some of that military records. If they were part of community programs, that also works. If they sent any money home to their home country, you could definitely use receipts from that. Also, birth certificates of children who were born here in the U.S., bank transactions, anything around cars would be good to use for people to show that they were here, or other postmark letters. You could also use employment records. Those are good because usually people get paid either biweekly or every month. The thing with that, you just want to be careful to see what information was provided for the employment record, right? If it's a fake Social Security number, if it's a Social Security number of someone else, you might not want to include that.
Veronica, I apologize for interrupting. We're a little behind, so I'm wondering if you could wrap up in about a minute some of the sort of screening issues and who specifically should file a DACA renewal so we could move on to the red flags.
Yeah, definitely. All right, so just really quickly around currently enrolled, you just have to show that someone was in school. A GED program counts, as well as vocational programs could count for that as well. As you start thinking about who might be able to apply as an initial DACA recipient, you want to make sure that you screen them for basic requirements as well as red flags. If people have had any contact with immigration or the police, you want to make sure you get those records before you move forward. Also be clear about how you list manner of entry. Some people would say they enter without permission, but in fact they were waived in. So you want to note that on the application. And then even though inadmissibility and deportability don't really affect DACA eligibility, you want to make sure you screen for those because they could be problematic for upcoming applications or for other relief people will want to apply for, and then discuss any risks associated with submitting this application. Like I mentioned with documentation, you want to make sure that whatever you submit doesn't affect someone, right? It doesn't trigger an inadmissibility, right? It doesn't admit to any elements of a CIMT or a drug criminal offense. And then also make sure that what you list doesn't trigger any of the other bars. I just want to note that the permanent bar does affect minors, right? So you also want to be on the lookout for that. And then just really quickly through renewal applications, right? Submitting a renewal is a lot more simple. Most people to renew would just have to prove that they are eligible for DACA or have been granted DACA, show that they haven't traveled and that they've been here in the United States since, and then that they haven't been convicted of any crimes. Usually all that's needed to submit a renewal would be your current work permit. Just wanted to note that if a person has had their DACA expired for more than a year, they will have to file as an initial, submit all that documentation I went through with initials with their new renewal application. And then right now during COVID, it's going to be hard to get some of these documents, so definitely see what you could find online around maybe purchases or bills or memberships, and then also seeing if there's any family documentation that could support, and then also maybe some of the administration's offices are still open. And then this is what to include in the application packet. As we know, the fee is $4.95, paid to the Department of Homeland Security. And then now I'm going to pass it over to Krishna.
All right, thank you so much, Veronica. I think before I start the next section, there's a lot of questions and a lot of useful comments. Someone mentioned that they've also heard of other rejections besides the one that we mentioned earlier. So if you all have any knowledge of receipts of initial filings, please let us know in the chat box so we can keep track of those. That includes like both rejections, denials, or acceptance of, but we haven't heard of those. Okay, so in this section, I'll be going over the criminal bars, which apply to both persons who are seeking to renew their DACA and also obviously for initial applications. And also talk a little bit about other red flag issues, including prior removals. So the USCIS guidelines provide that individuals convicted of certain crimes are not eligible for DACA. For those of you who need a refresher, the DACA criminal bars are independent standards and are distinct from the criminal bars that apply to other immigration benefits and forms of relief. Under these guidelines, persons who have been convicted of one felony, one significant misdemeanor, or 3 or more non-significant misdemeanors, or are found to pose a threat to national security or public safety, these persons are generally barred from renewing DACA or for filing for the first time. So let's go over these in more detail. Here, when we're looking at being barred for being convicted of a felony, we are looking at any federal, state, or local offense with a potential sentence of more than a year. It's important to note that the potential sentence is what controls in this case, so it's not what the law's label is. So, for example, a state law that labels an offense with a potential sentence of more than a year as a misdemeanor would nevertheless be a felony for DACA purposes. Also important is to remember that it is a possible sentence that counts, not the sentence that the person actually received. So if a law states that a certain act is punishable by 2 years, for example, it doesn't matter that the person was only given a 6-month sentence. This would still be considered a felony because the potential sentence would be more than a year. Now let's look at misdemeanors. This refers to any federal, state, or local offense with a potential sentence of 1 year or less, but greater than 5 days. So in other words, we're looking at offenses with the possible sentence of at least 6 days to a maximum of 1 year. And again, just like with felonies, it is the sentence, the potential sentence of the offense that counts, not whether the law labels the offense as a misdemeanor or not whether the person received, or not what the person actually received. It's what we're looking at the potential sentence. Here, when we're looking at significant misdemeanors, USCIS explicitly mentions the following categories as being significant misdemeanors. That includes burglary, domestic violence, drug trafficking, DUI, sexual abuse or exploitation, or unlawful possession or use of a firearm. So if a person is convicted of any of these categories and the potential sentence under the statute is at least 6 days to 1 year, it will be considered a significant misdemeanor. Besides these categories, USCIS also considers any offense where the person was actually sentenced for more than 90 days in jail to be a significant misdemeanor. So here we are actually looking at what the person actually received, so what they actually served in custody. So those are considered significant misdemeanors. And remember, you only need to be convicted of one of these to be barred. We also know that USCIS considers non-significant misdemeanors to be, I'm sorry, I didn't realize that the slide actually, I had to click on it to show the information. So here you go. So on the right column, you'll see that CIS considers non-significant misdemeanors to be misdemeanors that are non-significant by category, or for which a person was sentenced to more than 90 days in jail. CIS also states that the three non-significant misdemeanor convictions must not have occurred on the same date and not arise out of the same act, omission, or scheme of misconduct. So the three non-significant convictions must really be separate convictions. And remember, the potential sentence of each of these convictions must be at least 6 days to a maximum of a year. On this slide, we see that there are some exceptions to what doesn't count, doesn't bar someone. And I say, so something that doesn't automatically bar someone from qualifying. I say that it doesn't automatically bar someone because although it might not be an automatic bar under these criminal convictions, CIS can still consider some of these things when assessing national security or public safety considerations, which I'll talk about in the next slide. But just to give you examples, some of what don't automatically disqualify someone is if they've received a juvenile delinquency adjudication, if they've received an expungement for their convictions, or minor traffic offenses. All right, so when assessing whether a person is considered a national security or public safety, USCIS looks at the totality of the circumstances. So this basically means that everything is up for grabs, including any criminal contact that doesn't necessarily lead to a felony or misdemeanor convictions. Importantly, CIS explicitly does state that they consider gang membership to be specifically a threat to public safety or national security. So when we're flagging folks for eligibility, we really want to make sure that we're screening for this especially. Lastly, USCIS does maintain that it has the discretion to grant DACA if there are exceptional circumstances involved. This is extremely rare, and we only know of a few applicants, but if you have been successful in arguing that there is an exceptional circumstance, but please let us know in the chat box. But generally speaking, these can include evidence that the person has rehabilitated, that they are involved positively in their communities, any educational achievement, hardship to the applicant and family, or other family ties. So these are some examples of how someone can show an exceptional circumstance in their case, besides even if they are generally barred under what I just mentioned previously. Lastly, I just want to mention that persons with removal orders also remain something that we should consider when we're seeking to apply for DACA. And this is because they remain a high priority for ICE. So although it is not a bar per se to apply with a removal order, it is a risk. Many of you know that there were journal articles not too long ago highlighting the fact that DHS was asking to reopen previously administratively closed cases where the person was in removal proceeding. And other articles too, when they've asked ICE specifically what they plan to do with folks with removal orders, and they're saying that they're getting ready to go after them if DACA is terminated. So right now we do consider folks with prior removal orders to be a red flag, and you really want to talk to the client and talk about the risk of applying. So with that, I'll hand it over to my colleague Allison Davenport, who will continue talking to to us about what it is that we have to talk to our clients about when we're making a decision whether to move forward with an application.
Great. Thanks so much, Krishna. And yeah, we walked through, the requirements, the application, the red flags. Now we kind of need to put this all together and think through how to approach our decision-making if we ourselves are thinking about applying for DACA for the first time, or how to approach our consultations and conversations with clients. So let's take a few minutes to think about kind of what are some of the risks and benefits and some of the considerations. Obviously, community members, legal service providers, everybody is confused and struggling with what is the right thing to do given all of these kind of mixed messages we're getting, and how to balance, the best interest of your clients, taking advantage of opportunities with also, protecting them and not taking undue risks. So let's go ahead and unpack some of these considerations. So there's several reasons that people might want to file for DACA for the first time right now. As we stated, a second termination is likely. The president has indicated that. The Supreme Court decision gives them a lot of guidance on how to do that in a way that's legally sound, unlike their first attempt. So people want to take advantage of the current window. We also know there is a possible new fee schedule that's going to come out possibly this year, and that would increase the fees for many, many kinds of applications. It would also impose a fee on the 821D DACA application. So we would see the cost of applying for DACA go up from $495 to $765. So that's, just a financial, a practical consideration for a lot of folks, especially considering the pandemic and some of the financial hardships people are experiencing right now. Another reason is there are, strategic legal reasons. A legal service provider might encourage a recipient or an eligible individual to apply for DACA right now. Avoid accruing unlawful presence if someone has recently turned 18 years of age and is likely going to have to consular process. Some people are thinking strategically about advanced parole. There might be other factors in someone's case that makes it kind of a strategic kind of long-term strategy decision. If someone is already in immigration court proceedings, obviously, you have nothing to lose. You're already in the system, and you want to pursue any type of relief that you might be eligible for if you find yourself in that situation. There's also folks who have other legal options. Either they've already filed for other kinds of immigration programs are on wait lists, or they are eligible for something else and are preparing that application. So they're just going to throw kind of their hat in the ring with DACA and kind of, pursue as many options as they can. But they do plan to kind of file an application and be part of the system. It's also, this may also be a factor is if someone has potential relief in immigration court, so kind of thinking about a plan B, worst case scenario, if something goes terribly wrong and someone ends up in immigration court proceedings, are they eligible for relief before an immigration judge? So that might be a factor that makes someone a little more bold in this moment. Another thing, and we're hearing from a lot of you about rejection. So we are seeing some sprinkling of rejection of initial applications right now. This in one way makes you think, well, I'm not going to bother applying because they're going to just be rejected. But a rejection versus a denial is very low risk. A rejection is something that happens in the mailroom at CIS. They repackage your application, they don't cash your check, and they send everything back to you with a rejection notice. And if there is going to be litigation in the future challenging USCIS's inaction in light of the Supreme Court decision, people who apply and were rejected might be members of a class that could later benefit from some program like DACA or some special provisions for people who applied based on the Supreme Court decision. So tracking the rejection trend, it seems like a really important piece of the puzzle right now. We're going to do our best to track the trends across the country and to get that information out to you over our listservs, and we'll talk at the end about, how you can stay in touch with us and other agencies for more information and updates. And then, I just want to also highlight, there's personal and family reasons that someone might want to apply right now. Access to certain kinds of benefits, the need to secure employment, health issues, especially during the pandemic. I don't think we can, undervalue how important some of those personal and family choices are. So, there's always the legal piece, but then also the personal and family piece is so important. So those are some of the reasons somebody might want to go for it. Despite all of the confusion, that they might want to just pursue that initial DACA application. Other folks are, more hesitant and prefer to wait. So there's folks, clients, and service providers who just really want clear guidance from CIS. Like, I'll file on behalf of my clients, or I will file my own application once I see that there's a clear path for me to do so and I know kind of what to expect. Some people want to wait and see over the next few days or few weeks what is happening with initial cases. Are they all being rejected? Does that mean I should file and be part of maybe some future litigation, or does that mean I just don't want to bother? It makes me too nervous. So kind of watching trends. So it doesn't mean maybe you're saying no to applying for initial DACA forever, but for right now, you just kind of want to wait and see. There may be cases that have red flags present that heighten the risk for that individual applicant. So Krishna just walked us through, criminal bars and other issues, immigration history. There are some issues that are going to be complete deal breakers for people, so they wouldn't be eligible, and it is not in their best interest to move forward with an initial application. But other issues are just negative discretionary factors, and we just don't know how these initial applications are going to be adjudicated compared to previously prior to the 2017 termination. So it may just be that given all the uncertainty, someone may not want to go forward because they have some of these negative discretionary issues in their case, and because we don't know what the adjudication patterns are because we're not seeing initials being adjudicated. Potential loss of fees and financial constraints, again, especially during the pandemic, people are really financially strapped, and it, even the $495, even if we don't see a fee increase, is just a significant amount of money. Obviously, if we're seeing rejections, the risk is a little bit less, but it may be that some people just simply, given competing demands on their resources, don't want to move forward right now. There are individuals that just have a lower tolerance for risk. They don't want to deal with the uncertainty. There may be personal or family reasons, health reasons, economic reasons that this is just an additional source of stress that they just simply don't want to deal with right now. So we always want to talk about kind of those personal considerations as well as our kind of larger legal strategy. So those are kind of some things on the wait side. So putting it all together in a conversation with a client, or as you're making your own decision about an initial DACA application, thinking through all the benefits, identifying what are the risks, especially given like your personal circumstances and history, thinking not just short term about DACA, but long term. What are my other options? What would I do in immigration court? Kind of what is my plan B and plan C? So we're not just making a decision about today, but we're really thinking long term. Again, not undervaluing personal considerations, especially at this moment. And then, we want to give people time to think through their options, but we want to make them aware how time sensitive this is. If there is, a second termination, it may not be that the window is going to be open forever. If someone decides they do want to proceed with an initial application, we want to support that client's decision. You may want to talk through have talked through the risks and benefits, but maybe adding some language into a retainer agreement reflecting that conversation and describing those risks, like you don't know what might happen with their application. There are other cases being rejected, and just be really transparent about that. So at this moment, everybody is really clear and has a common understanding of what the plan is for that case. And always think through, a long-term strategy. What else can we do in this some Some folks are not comfortable doing initials right now because there are rejections, or they simply just don't have the resources, especially due to office closures and other reasons. They don't have the capacity to do initials. They're focusing on renewals, and they're very overwhelmed with that. If someone wants to proceed with an initial and you can't do it, try to, provide a quality referral to them so they can get the help they need. Try to figure out what is kind of the legal landscape in your area and who is doing the initials, or who's focusing more on renewals, and see how you can kind of share the load, and so people get supported and get services sooner rather than later, since this is all very time sensitive. If someone is eligible as an initial DACA recipient, and maybe as a legal service provider you think they should go for it and they just simply don't want to, it's still important to support that client's decision. Make sure they understand what their options are right now. Make sure they know how to follow up with you in case they change their mind or they hear about different trends in the news and want to kind of have an opportunity to talk with you again about that. The possibility, and then think through those long-term strategies. Again, provide a referral if some of their other options aren't something that you or your organization can provide to them. So really think big picture too. This is a kind of a high tense moment, I think, for a lot of folks, but we also want to make sure we're thinking big picture. Okay, so that's just an attempt to kind of put all of these moving parts together. One thing we haven't addressed and is also part of this big question about, is the program fully restored, is advanced parole? So we're going to pause our discussion on initial applications right now and shift gears and look at advanced parole. And I'm going to turn it back over to Krishna for that.
All right, thank you, Allison. So in this next section, I'll just briefly go over advanced parole, but like Allison just mentioned, like initial applications, we're waiting to see how USCIS will treat these applications. And as I'll talk about in a little bit, applying for advanced parole can also present its own specific risk right now, given what's going on. But for those of you who need a refresher, advanced parole is a way for certain immigrants to travel outside of the United States. It allows persons inside of the U.S. to receive advance authorization to re-enter when they return from going abroad. And under the SCOTUS decision, we believe that persons with DACA should be allowed to apply once again for advanced parole, but obviously there are things to consider, and what Allison just mentioned also applies to advanced parole applications as well. There are a lot of moving factors. There's specific risks that are involved. But just to go over the requirements. First, in order to get advanced parole, the person must fill out the form I-131, which is the application for travel document. Second, a person can't travel for any reason. They have to fall under 3 recognized purposes, and that is what you see on the screen. First, it has to be for a humanitarian reason, or for an educational reason, or for an employment reason. Some examples of humanitarian, we know that a lot of DACA recipients have a lot of family members who are abroad, who are maybe ill, grandmothers, grandfathers who are at an age where the person really wants to go visit them. Obviously for these, the person would submit evidence such as letters from physicians, from the hospital, just proving an illness if the person has an illness. For educational reasons, we know that some recipients in the past have studied abroad, or there's a conference that your school offers. So these are some examples of what can fall under the educational reason, and evidence of that would be brochures, letters from your school, things of that nature. And then lastly, we also know DACA recipients who have gone abroad for employment reasons. So for example, your job sends you abroad to negotiate a deal or to attend a conference to better your skills, things like this. And similarly, you would show evidence that, you're from your job, your employer, or any brochures, things like that, to apply for advance parole. But there are some risks to consider applying. Obviously, right now, like I mentioned earlier, like initial applications, we don't know how USCIS is treating them. But second, I think there are other reasons. If someone is allowed to travel abroad, there are rumors that DACA would be terminated once again. So what happens if they're abroad and this happens? Well, there is a risk that the person could be left outside of the country. Likewise, persons with prior removal orders, like I mentioned earlier, or other immigration bars that might not have been flagged, and now they go abroad, and when they're trying to re-enter, CBP now is screening them and finds this stuff, and that person is stuck outside. And then lastly, I think specifically what's going on right now with the pandemic, there are travel ban restrictions, and so you would have to assess what country that they want to go to and whether or not they're generally barred from re-entering. Right now, there's a lot of countries where the person could only re-enter if they're a U.S. citizen or a lawful permanent resident or their family members. So we really want to make sure that we're assessing all these factors when we're talking to people who want to apply for advance parole. And then lastly, we actually have a few people who have let us know already on the chat box that they have applied for advance parole. I don't think anyone has mentioned that they received a decision yet, but if you know of any applications, if you have applied for advance parole or are waiting for a decision, please let us know. We would love to keep track of those. So with that, I'll now pass it to Veronica, who will talk a little bit more about what we're hearing in terms of rumors. We've heard that there's an executive order or a bill that Trump might sign, whatever that means. So Veronica will talk about what could happen in the next few weeks.
Thank you, Krishna. So I'm going to go over some potential scenarios. This is a lot of speculation based on what we've heard and what we know so far around the DACA program and what we could expect in the coming weeks. Also, some ways that we could, protect some of the DACA recipients that we know, as well as the immigrant community in our area. So first, just talk about possible next steps or potential scenarios. There have been rumors of a recession memo coming, from the administration. It was heard from a source in the White House. Someone stated that it would happen, I think it was a week ago or 2 weeks ago. There's word that it might come in the following weeks. We don't know what the recession memo might say, but I just wanted to outline if, they follow what the Supreme Court stated, right? As Allison mentioned, the Supreme Court outlined what needed to be considered or what could be considered in a new rescission memo, right? So, the very basic DHS will lay out the reasons as to why they are terminating this. There has to be some acknowledgement around the forbearance issues, right, and the reliance interests, and how it impacts and hopefully provide some policy concerns that outweigh them, right, to give some clarity. There's also the possibility that, this new recession will provide a longer wind down period, right, to allow people to get their life in order, and also some of these programs to get some of their business in order. So hopefully we're looking at a longer period where people will be able to have DACA, and have work permits, but we don't know. This is just, if they follow this, I want to note that they don't have to follow these three things that the court outlined. They could do one or they could do another, or maybe they've been working already on some sort of memorandum or announcement that doesn't take any of this into consideration. There has been talk also of possible legislation About a year ago, the House passed H.R. 6, which is the Dream and Promise Act, but that hasn't seen much traction in the Senate, and it's been over a year since that was passed, so we don't know where that's coming, right? The new announcement around an executive action that Trump stated last week, he, wants to punt it over to Congress to take action again, but we don't know what that would look like. So we're just kind of waiting. I guess there's three possible things that we're waiting on to see what would happen, whether a new recession memo comes or a new executive action, and then seeing how that affects the program as we know it. And as we learned of new updates, we will definitely let all of you know and put up an announcement and resources on our DACA webpage. Also, I want to say, because there's so many unknowns, right, as next steps, I think as individuals who work with DACA recipients or members of the community ourselves, and I know Sandy's going to talk a little bit more about getting involved. I think this is a good moment to see how our local officials can ensure that, the government protects DACA recipients as well as all undocumented immigrant communities as we wait, to see what happens federally. And also there's been a push from Congress to get USCIS to comply with the Supreme Court, right? A letter from senators was sent out around that, and then just ensuring that we keep demanding for USCIS to, uphold this decision that was given, and then also, ensure that the information of DACA recipients remains confidential, right? So that's another worry, that information submitted would be used. So definitely a moment to demand that Congress ensure that this information is kept confidential. So I'm going to leave it there, and I'm going to pass it over to Sandy to talk a little bit more of how we could get involved.
Yeah, thank you so much, Vero, for sharing. And all of these walkthroughs are a refresher of what are some of the challenges and both opportunities with DACA, but another reminder of why it's so important for us to cultivate community power and create opportunities for empowerment from directly impacted folks. And this is an invitation for you all as service providers or folks who work with service providers, or who will be volunteering to support young people benefit from DACA this time around, to really challenge the ways and think about how you can innovate your service providing model, so that again, you take into consideration that you're not just interacting with DACA recipients and documented youth, but you are also interacting with families. I think in the state of California, 1 of every 2 kids have a mixed status family, or have someone who is a non-citizen person in their families. And so, that does call for us to really challenge the way that we're looking into service providing and what types of spaces we're creating for community empowerment and cultivating that power that continues to defend victories such as DACA, and it's also continuing to push the edges of what is possible, right? And DACA reminds us that of every time, right? That DACA wasn't just something that Obama woke up one day, right, and thought it was a good idea. That it was actually a response to demands that were built by community power and through the cultivation of community power and empowerment. And so, just some friendly questions for you, again, as service providers and as folks who work with service providers. How are you challenging criminalizing narratives? What are some resources that you can have available? What are some stories that you can tell, as you're providing a service that challenges the rhetoric that and the xenophobia that the administration is creating around immigrant communities? And again, how are you empowering undocumented communities to have self-agency about the way that they're being criminalized and the way that they're being targeted? And I wanted to share some recommendations of ways that folks can actively do this. Thankfully, in California, we're very lucky, and I know this also exists in many other states, to have rapid response networks that provide direct support when someone sees ICE or when someone is being targeted by ICE. So, and this is something very concretely that folks can have in their offices. There are, folks can see some resources here. Folks can follow the ICE out of California network. In specifically in the Bay Area, there's ASILEP, there's Stand Together COCO, and there's a really great connection also between these rapid response networks. And so even if, you know, you're not sure if that's the right number, there is coordination where folks will connect whoever is calling to the closest rapid response network so that folks are being able to be dispatched to verify ICE reportings. And, you know, on this note, you know, how are we creating more opportunities of power and not panic, right? And so as we're continuing to hear an increase of enforcement, and also in particularly non-DACA folks that are being targeted, you know, how are we contributing to the response to be from empowerment and not from a place of panic, right? And reminding everyone that undocumented folks have existed and have lived without protection, right, from deportations. And so just know that there is a strong resilience within undocumented communities. And, you know, a lot of the ways that undocumented folks verify, you know, safe ways that they can receive services is like word to mouth, right? And it is very cultural. And so thinking about how, you know, again, as service providers, you are cultivating this culture that empowers and, you know, doesn't bring panic onto our communities. If your office or, you know, if you know someone within your legal network who could provide support to people targeted by ICE, and if you have the opportunity to reach out to folks who are building campaigns and addressing the ways that folks are being targeted by enforcement locally. And this also means, you know, do you understand, you know, the way that your local law enforcement is collaborating with ICE, you know, and what are some of the ways that you can bring some education about those campaigns into your office or, you know, into your workshop space or, you know, even into your webinars now, right? Because we want to make sure that, you know, if folks are coming and, you know, aren't eligible for DACA or, you know, are simply reaching out for information, you still are getting that face-to-face connection with impacted communities that is really valuable. And again, us cultivating the power and empowerment that is going to uphold victories such as DACA and other victories as well. And one of the biggest opportunities I wanted to share with folks that's actually taking place this week, and a huge victory that impacts the way that folks are being targeted by immigration enforcement. Here in California, we've been leading the charge to hold private companies accountable who continue to profit off of the incarceration, detention, and deportation of immigrant communities. And we were victorious in passing a bill named AB 32 this past year that holds these private corporations accountable. And much as we expected, it is being challenged by the federal administration as well as these corporations who, you know, have made a large profit off of the criminalization of immigrant communities and communities of color, and specifically Black people. And so we want to make sure that, you know, we uphold this piece of legislation. There are a series of events that are taking place tomorrow. And I've provided the link on here for folks to also engage and join. And, you know, just a refresher that as long as these facilities continue to exist and as long as there is a driving profit off of the incarceration of our community members, there will continue to be enforcement and criminalization, right, that is really impacting the way that our immigrant communities are able to thrive. And so, you know, please also look to us as a resource in the ways that you are looking to innovate your face-to-face interaction with impacted communities. And if you're looking for ideas to push back against criminalizing narratives, there are a lot of great resources on our ILRC website. And again, the Dignity Not Detention Coalition and the ISAT of California Coalition here in California are also really great resources for you all to pull critical pieces of information and campaign. And I'll pass it over now to Sally to also share more resources and opportunities.
Thank you so much, Sandy. And thank you, everyone, for your participation. While I'm talking, I just wanted to, again, ask folks to share through the chat box if you have filed initials and seen something other than a rejection, if you can share any of your experiences. And I wanted to share a resource to share beyond today's webinar. The Immigrant Legal Resource Center, we have a website, like many nonprofits. It's ilrc.org, where we post things like practice advisories, infographics, et cetera, on DACA. However, we also host a listserv, and you can find it by going to the top right corner of our website where you see subscribe. And then you'll get to a page where it will ask you if you want to join one of our legal listservs. And then at the top of that page, among the legal listservs, you'll see there's one called DACA Experts, which has hundreds of people on it. And it's an open listserv, meaning it's a listserv where you can post a question like, has anyone gotten a rejection on an initial DACA application? Does anyone have language that they're putting into their retainer agreement to outline the risks and their client's understanding of the risks if they file now? You can post things on there, and there are hundreds of other practitioners who can respond. So you really benefit from the expertise and the experience of the field beyond just those of us here at the Immigrant Legal Resource Center. So we would like to really encourage and invite you all to join that listserv so that you can be learning from each other and we can have shared understanding of where we are now with this constantly evolving and really uncertain DACA program. We have about 4 minutes left in our webinar. So I first want to open it up to my co-presenters to ask if there was anything that came up through the chat box or the questions that you want to address again verbally that you didn't have a chance during your presentation. And then at 12:30 Pacific, we'll go on mute and we'll continue to answer questions through the chat box for a few more minutes. First, any follow-up comments that came up through the chat box?
Hi, Sally. This is Veronica. I just wanted to give a brief note about renewals. I know there are a lot of questions coming in about renewals that expired more than a year ago. For those who have expired more than a year ago, as I briefly noted, an individual will have to apply as if they were doing it for the first time, so submit all the documentation proving the eligibility, but they will mark renewal on the application because they are renewing, but they just have to submit the evidence required as if they were an initial.
Great. Yeah, I think someone commented that some people feel like they've been doing initials the last few years as they helped renewal applicants who had DACA that expired more than a year ago. Thank you for that. Krishna, Sandy, Allison, any last thoughts or comments?
Yeah, this is Allison.
Krishna, oh, go ahead.
Go ahead. No, go ahead, Krishna.
Oh, I was just going to mention that I think on the chat box, a few more people have said that they received rejections for initial applications. We haven't heard of any denials, but just wanted to flag that. And then also other people who have applied for advanced parole but are waiting on a decision. So again, if you know of any cases, please let us know or sign up for the listserv that Sally mentioned to share in the future.
Thanks, Krishna. Allison, did you want to add something?
Yeah, just very briefly, someone reminded me in the chat box that, or in an inquiry that there is some thought that the certification of the Supreme Court decision does take some time. and that some of the rejections, the theory is that some of these rejections we're seeing is because they're being filed before the case is actually certified, which normally takes 25 days. And so that once that time has passed and now that the case is certified, that cases filed now should be accepted, and those cases should be processed. Otherwise, that would be a basis for a lawsuit. So we're just going to have to track this rejection issue and give advice to folks about whether they should be refiling those initials, whether there is a litigation opportunity, or obviously if we hear directly from USCIS about new processing guidelines. So just to let you know, there's lots of thinking about what's happening and why, and what are some options.
Thank you so much, Allison. And I think there are a lot of questions about what are the litigation opportunities for people who may want to be part of a potential class action if they file an initial and there's no movement on it. We have not confirmed who's litigating, but we will continue to ask. And thank you for those of you who through the chat box shared various things you've heard about potential litigation opportunities. We'll follow up on those and share what we can. We're at the end of our time, so I want to thank so much my colleagues here at the Immigrant Legal Resource Center, Allison, Veronica, Krishna, and Sandy for sharing your expertise and experience. Again, just to remind folks that we'll send you a survey. Please share your feedback for what could have been improved, what you would like to see more of. We'll make sure you also receive all the materials from today's PowerPoint slides, and also MCLE certificates for those of you who need continuing legal education. We'll also be posting updated information as we get it, including practice advisories and other information. So please go to our website. And again, also share whatever you see on our listserv. We really appreciate hearing from all of you. We'll go ahead and go on mute now. There are still, I believe, perhaps hundreds of questions in the chat box, so we won't be able to get to all of them, but we'll spend a few minutes trying to get to as many as we can. Thank you so much, everyone. Have a great day.